thanks to all of you. We're delighted to be doing this interview. And yeah, I think it would be because, after what you just said about me, which I have to thank you for, I guess that's the least I can do. And I want to range a fair bit in terms of a number of the things I want to ask. I'll start out with just a couple questions about on the judge side of things. I'm curious what, on several scattered things. What is what's a couple more memorable opinions for you? You've been on the court a long time, so.
Oh, okay. So there's a couple of that particularly stand out. The main one, I suppose, would be Hopwood versus Texas, which wrote in 1996, I believe it was. And Hopwood is a good example of how these legal issues have to percolate for a long time, and sometimes we get impatient. But as most of you know, Hopwood was the case in which we said that Texas Law School could not engage in affirmative action. Now, importantly, our dear, all of us departed friend and revered Professor Lino Graglia, when Hopwood was pending, Lino, whom unfortunately I didn't go to UT and have him as a professor, but some of you here did. But he predicted number one, that our panel would not overrule affirmative action at UT, and number two, that Lino actually thought that would be going a little bit too far. Now, in fairness to him, he was not a big fan of judicial review. I am a big fan of judicial review, but in any event, despite Lino Graglia, a wonderful man who was right at least 99% of the time, we went ahead and decided that in March, and then in July, the Supreme Court denied cert without a dissent, and so Hopwood has prevailed at least to that extent, and we see what the Supreme Court has done since then. The other case that stands out for me is corrosion-proof fittings versus EPA, which was in 1991, and that was an attack on the EPA's effort to ban all use and manufacture of asbestos in the United States. And I mentioned that case because for one thing, we installed a cost-benefit analysis into the review of the EPA regulation, which caught a lot of attention. And I'm told by my law clerks and others who have been to law school since then that case was installed for a long time in the textbooks for administrative law classes largely because of the cost-benefit analysis. One of the things that my very talented law clerk who wrote that opinion, drafted it for me, put in the opinion is that there were more people that died every year from toothpicks lodged in their throats than there were from asbestos. And one of the things that we pointed out was that without being able to have some use of asbestos back then, 18-wheelers would not be able to stop, and that might have been a problem. The reaction to the opinion was pretty strong. One of the leaders of one of the big environmental groups reacted this way. She said, "Oh, if we can't ban asbestos, we can't ban anything." And unfortunately, it didn't quite turn out true that way. But the EPA didn't even apply for cert, and that case has remained as good law. So those are the two that stand out.
Yeah, no, it's interesting. By the way, you mentioned law clerks. One of the things I was curious about is you've had a lot of law clerks, and I think for many judges, and I'm pretty sure for you, that's one of the really wonderful things about the job. But any of those specifically stand out, or anything that I'm not trying to get you to name them so much as I'm trying to get a sense of what's become of a lot of them.
Well, let's see. How about one U.S. Senator and 3 U.S. Circuit judges and 1 state Supreme Court justice and a judge on the U.S. Tax Court and a judge on the U.S. Court of Federal Claims and a member of the Federal Election Commission, and about 14, maybe 15 law professors from all over the country. And so I'm pretty proud of that group. But I should also say that there was one other of my law clerks who at least we would all agree is earning an honest living because he recently became a Catholic priest.
Right. Also, rumors you have one who's, wait, no, you didn't, no, never, I'm sorry. I was thinking of.
But so I should mention, I mean, for example, I mean, I've several of my past law clerks are here, and Justice Jimmy Blacklock, for example, from the Texas Supreme Court. And of course, Jim Ho, whom you've heard of, a great colleague on our court. I should also mention, while I'm mentioning great colleagues on our court, Edith Jones is here, and she's fantastic and has been a great mentor to me. But those are some of my law clerks who stand out.
Yeah, no, it's interesting, and then one of the things with the judges, there's quite a life behind most of them, and doubly so in your case. Let's switch a little bit to a couple of earlier. What was the first political experience you ever had?
Well, so I was thinking about this. So it actually was when I was 7 years old, and my dad and I had been to a meeting of an organization, Dads and Sons, and at the meeting, this was during a big gubernatorial election in Texas. There was everybody was Democrat back then. There were no Republicans, but it was the liberal was Ralph Yarborough, and the conservative was Alan Shivers, and they were running against each other in the Democratic primary. And the men in the group were sitting around and discussing the upcoming election. And I thought everybody in Lubbock, this was in Lubbock, was would have been for Shivers. But this one dad said that he was voting for Yarborough. And when my dad was driving us home after that meeting, I said, "Daddy, I don't understand, Mr. So-and-so. He seems like such a nice man. I mean, how could he be for Ralph Yarborough?" And my dad, and this was a lesson that has stuck with me. That short conversation. But he said, "Jerry, let me just explain to you that there can be very good people on both sides of an issue, and this man is a very good dad and husband, and we respect him, and we have to respect other people's viewpoints, and don't hold that against him." And that really has stuck with me since then. But that's my first political recollection when I was 7.
I'm going to link in something else here because I think there's some way in which it's related. You, of course. And all judges have backgrounds, usually very involved in public policy and politics, and then they become judges, and that's the end of that. But you actually, as very involved in the Republican Party in various ways, et cetera, but you ended up working as a city attorney of Houston under a liberal Democratic mayor. How'd that come about? And does that speak at all to what we just talked about?
Yeah, and it caused everybody to think that I was a real flake too. a real sellout. So the way this thing happened, I mean, one of the nice things to me about local government, at least in Houston, is that it's nonpartisan and it's possible to work issue by issue. So does anybody remember Proposition 13 in Howard Jarvis in California? Well, that was a very popular tax limitation effort. So in Houston, we had one of those referenda going, and our city controller, she was a CPA by profession, and was very actively working in favor of the tax limitation proposal as a matter of hard-nosed, tight-fisted city government. And my wife, Mary Jane, by the way, who I give great credit for everything I've done, she's very generous in supporting me in everything, but she and I worked on that campaign for that referendum, and it passed, and it's still part of Houston's city charter. But in any event, that gave us some acquaintance to this particular group of people, mostly Democrats, who were at least working on that particular issue. And so, as it turned out, by getting to know them and getting to work with them, as it turned out that this woman then was elected mayor, and asked me to be city attorney, and I saw some opportunities to do some good things in the city and to assist, and so I was city attorney for 4 years. We worked on some, again, issue by issue. It was very refreshing. City Hall is in charge of boring things like paving streets and fighting crime, and I was able to lead the city's legislative program in the state legislature to bring about some reductions in employee benefits that kind of saved the city from bankruptcy back then. Another thing in Houston is we have no zoning, and it works great to have no zoning, but my department was in charge of beefing up enforcement of deed restrictions to assist people in protecting their property rights, and kind of on the social issue or moral side, we were beefing up regulations of sexually oriented businesses in the city. So these things were things that I had in common with the people at City Hall, and I was glad that I had taken on that opportunity. As it turned out, I mean, I guess I either did something very right or something very wrong, because when I was nominated for the judgeship, I got a unanimous endorsement from City Council and favorable editorials from both the conservative and liberal Houston newspapers. So I went, after 4 years of that, I went on to the judgeship.
There was another experience I think you had that might have contributed to that. And I think this was before you were in the mayor's office, but there were charges about police brutality in Houston. And the story I'd heard was that there were 3 members of a commission to review that. One was clearly very pro-police, one was anti-police, and very not saying there's brutality. And you were the third one who I think a lot of the pro-police groups were very pleased at the time when you were chosen. You want to tell us about what happened there, because it's always struck me. I heard this story.
Well, I was chair of the City Civil Service Commission. This was a volunteer job while I was still at the law firm before becoming a city attorney. And we did aggressively go after some pretty serious police misconduct that no one in this room would disagree was serious misconduct, including brutality and misbehavior. We were the first commission ever to bust anyone as high as an assistant chief, and it got the attention of the city employee unions and police and fire and municipal, and I think raised the stature of our commission. Also gave me my first taste of what it would be like to do some judging, because we had hundreds of evidentiary hearings in which I found it was kind of satisfying to sit behind a table and listen and try to figure out which witness was telling the truth. So I thought. Yeah. I kind of like this.
Right. Well, good preparation. Okay, let's go back for a second to a couple of things related to judging, and let me throw out a couple questions about the various things, and you may or may not be able to comment on them. But one of the topics that's come up a lot, not quite as much really recently, but a lot, is national injunctions. Do you have any reaction or thoughts on that you can share?
Well, my answer is kind of a non-answer, which is it depends on the case. But let me say this: it's really, I think, short-sighted to either say that national injunctions are a good thing or national injunctions are not a good thing. And there's too much emotion shown on that issue on one side or the other. For one thing, the scope of an injunction can range anywhere from 3 or 4 different stages. Number one, it could be an injunction against only the parties to the case. Number two, it could be an injunction only in the district where the ruling is made. Number three, it could be a statewide injunction. Number four, it could be a circuit-wide injunction. Number five, it could be a nationwide injunction. And we have a lot of those pending from time to time, and I'm not going to obviously express any kind of opinion about the specifics of what we evaluate, other than to say that nationwide injunctions are neither all good or all bad, and it has to depend on the case.
It makes sense. What about sort of the so-called shadow docket?
Okay. Yeah, the shadow docket has really been misnamed, this kind of sinister something lurking in the shadows. We've always had what we called an emergency docket, and the Supreme Court has had the same thing. Suddenly it comes up because things are being decided on that docket with results that certain people and groups don't like. But it's absolutely necessary to bring some things to the attention of either our court or ultimately to the Supreme Court that have to be dealt with promptly. And we've always had those kinds of cases. Our court has separate administrative panels, and these can come up, on an overnight basis, needing a quick resolution. The criticism has been, well, this isn't fair because you haven't had full briefing over a period of weeks or months, and you haven't heard oral argument, and there hasn't really been time to decide the case thoroughly. Well, in fact, let me say that sometimes just the opposite is true. That is, let me explain. Cases can get lost in the shuffle if we go to New Orleans and hear 20 cases and then go back the next month and hear another 20. And sometimes these cases can linger for a long time. They've been thoroughly briefed and we have other things to do. And weeks or months later, finally, the judges, maybe one by one, and the law clerks give attention to the case, and ultimately a decision is reached. I sometimes find it very refreshing and efficient and absolutely correct to decide things on a short-term basis. Why? Because all three judges and their sets of clerks are focused on the case and give it their undivided attention. Why? Because it's an emergency, or if at least it's something short of an emergency, it's something that has to be decided in a short period of time. Someone's scheduled for execution, or there's an election coming up, or there's a law that's getting ready to go into effect, or a judge has entered or denied an injunction and that needs immediate attention for whatever reason. Sometimes the best decision making is that kind of focused, concentrated, and uninterrupted decision. So again, it depends on the case, but it's completely misleading for people to criticize the fact that some cases are decided in a period of days rather than a period of months. And I say the same thing about the Supreme Court and their docket.
Right. Interesting. Yeah. One other sort of semi-controversial thing, I suppose, single districts in Texas, which I don't know much about, but I gather is a big thing here.
Single-member districts or single-member divisions. So there was a lot of discussion about that earlier today, and I pretty much completely agree with what was said earlier. There is absolutely nothing wrong with having single judge districts, and these have gone on for a long time. You could say it affects one side of the docket or another. An example I can remember back decades ago when lots of statewide cases were filed in Tyler with Judge William Wayne Justice, who ended up ruling on the state prison system. I was one of the lawyers for the state in that case many years ago, and I didn't hear any criticism of the fact that it was possible to go to Tyler and there was only one judge there and have the case decided by that judge. I clerked for Judge Woodward for the district court in Lubbock. He was the only judge for Lubbock, Amarillo, and San Angelo. So any case that from those divisions that was filed would be heard by Judge Woodward. And I looking at that from the inside, it seemed to work fine, and nobody complained that those cases should have been randomly assigned to other judges.
Yeah, Judge Connor had said something about this at the start, I think.
Yeah. There's been a lot of discussion about that today. And by the way, this is one of the things that a mention was made earlier that judges need to speak out about this. As you know, the ethical rules properly prohibit us from getting involved in discussion of all sorts of national, political issues, or even sometimes legal issues outside the cases that we're actually deciding. But it's perfectly well understood that judges are not only able but encouraged to speak out about and get involved with issues having to do with the structure of the courts and the operation of the courts. And so those of us who feel one way or the other about that issue are perfectly free to discuss it. And my opinion is pretty clear, which is that the judiciary and Congress need to leave this issue alone.
Right. One thing I've noticed is you've never been shy about, within those guidelines, expressing and disagreeing with people, nor have you ever been upset when people disagree with you, which is a little different from the way much of our political system works. But speaking of which, there was a time when Trump was president when at least one or two scholars were saying, on the conservative side, were saying, boy, we should really add some judges here, sort of while we're in control, et cetera. And of course, there's also been talk about the Supreme Court on the Democratic side. Do you have reactions to either of those? Where
court packing is what you're talking about.
Yes, court packing. Yeah. Court packing at any level and by different groups.
Yeah. So I thought this was very, very unfortunate and unwise, and I spoke out about it at the time. There was a scholarly piece that was floated on SSRN, and the suggestion was that it didn't say that now that Trump is president, but it all of a sudden came up once he became president.
Right.
And this lengthy article, which largely relied on research that was 30 years out of date, but I'll pass over that for the moment. This sudden recognition that the federal courts of appeals were so swamped with cases that our situation was hopeless, and that we were forced to write hundreds, if not thousands, of unpublished opinions that were sloppy and not well considered, and oftentimes wrong, and that we did not have the resources to study the cases carefully because we were short of judges. And we were so short of judges, as a matter of fact, that as for the Fifth Circuit, overnight, the Fifth Circuit should be increased from 17 judges to over 50 judges. In other words, a tripling in the number of judges that we would have overnight to try to decide our cases. Well, it's hard enough to deal with an in-bank court of 17. I can't quite figure out how an in-bank court of 51 would work. But in any event, I thought that this was a fairly blatant effort at court packing, and Congress, I hope, never would have done it. It was also disparagement of federal judges around the country appointed by the last 8 presidents, because the suggestion that we would put up with turning out sloppy or irresponsible work over a period of years and would not complain that we were short-sighted, I thought was extremely unfair to judges appointed by both parties. And of course, it's interesting to me then that once the presidency changed, that a lot of people on one particular political side of the ledger started talking about a 50% increase in the number of justices on the Supreme Court.
Right.
So that's my view of court packing. It's never a good idea.
By the way, there's a solution to your en banc problem. Just look at the Ninth Circuit. Their en banc, of course, isn't all the judges, and that's, I assume, what you'd do if you had a court of 50. But it's not obviously desirable.
Yeah, well, one of the things that is kind of interesting to me, of course, most of our cases are decided by panels of 3, as all of you know, but our en banc cases are some of our more important ones, and because of the Ninth Circuit rule, we actually are the largest en banc court in the country, because we're the second largest court, but we don't have what they call the mini en banc, where the Ninth Circuit only has 11 sitting en banc. So no other court actually the Sixth Circuit has 16, so one fewer than we do. But that's a large body to try to reach decisions on important complicated cases, and it's a different dynamic from some of the smaller courts, and it's one of the most challenging things that we do.
Yeah, a couple other questions on things concerning your, concerning a couple different things. So the rumor is that you have never split an infinitive, nor have you ever written a concurring opinion. Both are pretty unusual, I suspect unique. I'm just wondering, is that true, and is there a connection?
Okay. Number one, it's true. Number two, I can't think of a connection. But I'm glad to discuss.
It is something up with which you will put.
That's exactly right. Yeah. So I think ultimately on things like grammar, particularly, it's important to hold the line on things like split infinitives. And the beauty about the split infinitive, I know everyone's rolling their eyes. Here we go, down in the weeds. The beauty about the split infinitive is that when you say no split infinitives, it reads really awkwardly. And that's important because it means that we're doing a rule for the sake of the rule. I mean, it's very much Old Testament when you think about it. The idea that it's the rule and that we've always done it that way, and I think it's important just to maintain that absolute rule. I don't correct other judges when they do it. Lots of our opinions have split infinitives, but I think we need to hold the line on that. Just a quick, if I could take. Let me move quickly into mistakes like this in opinions, because since we're in Fort Worth, I'm going to do this only because we're in Fort Worth. So internally within our court, I circulate this list of common mistakes that our court makes about misnaming a statute or misnumbering things or whatever, things that just we need to watch out for that are across the board. One of the ones that's on my list, and this is only a list of about 15, is misspelling Fort Worth as Fourth Worth. Now, you may think, so what? If you do a Lexis or Westlaw search, you will find lots of Fifth Circuit opinions and one Supreme Court opinion that says Fourth Worth. The way that happens, I think, is that spell check doesn't catch it because Fort and Worth are both words, and also that subconsciously people use the fancy word forthwith and they think about it. But you see this logo up here? When the announcement was made about this conference several weeks ago, the initial draft of that, instead of saying Fort Worth, it said Forthworth. So it can.
How embarrassing!
It can happen. Can I take my one more jab at Fort Worth?
Yeah, sure.
Fort Worth is a great town.
I don't live here.
I grew up in Lubbock. Lubbock is 300 miles from anywhere larger, but the closest thing that's larger is Fort Worth. We really get put down by Fort Worth and Dallas, and there's a real inferiority complex about, if you live in Lubbock, about these two big evil cities that are 300 miles away. So, but I still consider, Lubbock as hometown. All right, so a few years ago, this was maybe 20 years ago, there was a lawyer from Fort Worth who came to New Orleans to give oral argument in one of our cases. Lawyers, I think, want to start off their argument maybe by saying something funny or something relaxed just to get just to get something started. So this lawyer thought he'd be pretty clever, so he stood up, went up to the podium and said, "Your Honors," I could see his family sitting in the front row. It was in the summertime, the kids were there, and everybody was there, and he was so proud, and he says, "Your Honors, I'm so glad to be able to represent my client here today, and I'm particularly glad that we're able to come to New Orleans for this argument, because the last time I had a Fifth Circuit argument, we had to go to Lubbock." Do I need to tell you that he lost the case? No, it had nothing to do with it. All right. That's the end of Fort Worth today. So that's it.
Well, I'll get you into trouble in other ways. As an originalist, which I think you basically are, and a baseball fan, what would you say about the designated hitter or starting extra innings with a runner on second base?
Yeah, so for all these years, I've had this internal debate. I'm trying to figure out which is worse, the designated hitter or interleague play or this extra inning thing. And it's part of deconstruction of society as far as I'm concerned. I think the DH is probably still worse, but it's really hard to say. I have to say that baseball has played a really important part for me all of my life. My father, whom I referred to earlier, taught me a long time ago to hate the Yankees, and that's continued. And I can well remember, this is for the baseball geeks, but I won't go into the details. So I can remember in ninth grade, social studies class, and we were discussing the Electoral College, and I was the only kid willing to stand up in class and defend the Electoral College, and I used as my reasoning the results of the 1960 World Series. I won't go into it, but if you're a real baseball geek, you'll understand, or you can ask me later, what the 1960 World Series had to do with the Electoral College.
Other than the Pirates winning at 4-3 and being outscored by the Yankees by about 60 runs or something. So I'll do one other thing. I want to ask about baseball. I want to know if baseball or Joe Biden is more responsible for your being a judge.
Yeah, that's a good question, because they both helped a lot. So let me explain. The position that I ultimately got on the Fifth Circuit was vacant because it was a brand new a slot that had been, no judge had held it. And there was a Democratic senator from Louisiana who wanted the seat to go to Louisiana. And with the administration, Texas was underrepresented, and so I got nominated, and the senator from Louisiana, being a Democrat, talked Joe Biden into holding my nomination, and it was held for several months because he was demanding that he wouldn't release his hold until the seat was given to Louisiana, and ultimately Joe Biden, I think, probably with some help from my Democratic boss at City Hall, convinced Biden to release the hold despite the objection, and so he did finally release the hold. Just to give you an idea of how the nomination process has changed So I was nominated in June and finally confirmed in December of the same calendar year. So that was roughly 6 months. I was the longest pending circuit nomination for that entire calendar year. That tells you how much more smoothly things ran back then, but thanks to Joe Biden. But backtracking a minute on baseball, because there was some controversy within the Reagan Justice Department about whether I was the right one to fill the position. There was some suspicion that I was part of this Democratic administration at City Hall, and was I a flake or a sellout, and could I be relied upon? And the man who was pretty much in charge of making the decisions on who was to be nominated, this was within the Justice Department, I think was pretty much undecided or leaning against my nomination until he found out that he and I were both longtime dues-paying members of the Society for American Baseball Research. And he decided that anyone who was that geeky and down in the weeds about loving baseball, maybe it was worth giving me a shot. And he did come to my investiture and talked about all that once I was confirmed.
Well, certainly you knew you were a patriot if you were that interested in baseball.
Of course.
And
oh, and by the way, speaking of baseball, at Yale Law School, we weren't all that serious about learning things. And,
right. They still aren't.
So we had all these assigned cases for my first day of my first year in law school, and some of the new law students were boning up pretty heavily on reading those and being prepared for the first day of class. But there was a really important Mets-Cubs series at Shea Stadium, and I thought it was more important, so I drove to Shea Stadium and watched the game and got back to my dorm about 3 in the morning and crashed, and I guess was not well prepared for my first day in law school.
By the way, people who have questions or get a couple more, but can, if you want to go to the microphone, if you have questions, please do so. I had a different question. What about the job, and perhaps even about other judges, have you found the most annoying over the years?
Oh, okay. Well, generally speaking, I mean, we're on a wonderful court with fabulous people, and so I'm honored to be able to work with all of them, and they're all very dedicated and very honest and absolutely brilliant jurists. And I mean that sincerely. It's a fantastic group of people, but I think maybe the two things that are the most distressing are people who are unable to make quick decisions about things, so that things linger longer than they should. And I guess the second thing is what I'll call kind of maybe sort of self-righteousness about people having to express their own individual views about things that kind of breaks up the continuity and sometimes the unanimity of the court. And I don't mean that critically of any particular judges, except to say that sometimes the court really does need to speak with one voice, and that's why I've just decided through the years, not to write special concurrences. But I thought you might be asking something about that, and I did bring one thing that I want with me that I want to quote from, if I may, in this regard about decision making in a collegial body. We just celebrated, as you know, this past week, Constitution Day. And one of the things that I read in connection with that was a recount of a speech that Benjamin Franklin gave toward the end of the Constitutional Convention. And I'm going to read from it. It won't take long, but I think it's important to talk about how it relates to decision making. Franklin was in extremely poor health and wasn't even really able to deliver the speech himself, but he wrote it out carefully, and it was delivered by someone else. And here's what he said. I confess that I don't entirely approve of this Constitution at present, but, sir, I am not sure I shall ever approve it. For having lived long, I have experienced many instances of being obliged, by better information or fuller consideration, to change opinions even on important subjects, which I once thought right, but found to be otherwise. When you assemble a number of men to have the advantage of their joint wisdom, you inevitably assemble with those men all their prejudices, their passions, their errors of opinion, their local interests, and their selfish views. From such an assembly, can a perfect production be expected? It therefore astonishes me, sir, to find this system approaching so near to perfection as it does. He's talking about the Constitution. And I think it will astonish our enemies who are waiting with confidence to hear that our counsels are so confounded like those of the builders of Babel, and that our states are on the point of separation, only to meet hereafter for the purpose of cutting one another's throats. Thus I consent, sir, to this Constitution because I expect no better and because I am not sure that it is not the best. On the whole, sir, I cannot help expressing a wish that every member of the convention who may still have objections to it would, with me on this occasion, doubt a little of his own infallibility, and to make manifest our unanimity and put his name to this instrument. That word infallibility is so important, I think, for every judge to remember as we have the give and take of a collegial body of 17 judges and trying to come to a consensus where each of us has his or her own strong ideas about decision making. And I think the words of Franklin speak volumes in terms of how we should approach that.
When you say how we should approach that, do you mean how judges should approach it, or do you mean it much more broadly?
Oh, I think it's both, actually.
Yeah.
I think it's both.
A corollary question I have, which I think I can ask a judge. One thing which has bothered me is as the country becomes more and more of a situation where half of the population, certainly half of the politically active population, seems to view the other half of the population as not only just wrong or misguided, but evil. That's a real challenge to how the country moves forward over the years, because it's we had in the earlier days, one thing, we've always had disagreements. I call one prominent early politician and member of the Congress, whatever, saying, sir, that rule might be all very well for the good citizens of Pennsylvania, but for the barbarians of Georgia. So that's a constant strain. But how does that cause you concern? Does that relate at all to what you were saying?
Well, I think there's two ways to look at it. I think it makes a difference what we think and what we say, and I think it's probably unwise, almost without exception, to make those sorts of personal attacks to impugn motives in our opinions, even though we may think that has somehow worked its way into the decision-making process. On the other hand, there's absolutely nothing wrong with strong, definitive opinions and strong, definitive dissents. And there's a difference between saying it and saying it in a way that really undermines the credibility of the statement by questioning other people's motives. It really goes back to this thing about when I was 7 and trying to respect other people's points of view. But don't misunderstand anything I say to suggest that opinion should be watered down in terms of the strength of the holdings. And that also gets back to maybe not why I've chosen not to write special concurrences, but to join majorities and work with the majority opinion writer to try to make the opinion better before signing on.
Yeah, no, that makes a lot of sense. Once again, invite any questions. I can continue to ask questions, but I want to make sure everybody has a chance to ask what they want to ask. I will throw out a question about Yale, both undergraduate and law school. What was it like then?
Okay. So one of the things that people may not realize who see all of the campus violence nowadays is that's absolutely nothing new. And I mean, let me just mention two or three things about my days at Yale Law School, because in so many ways, really nothing has changed. The grading system was the same then as it is now, and it was pretty easy for people who wanted to coast through without doing much work. I feel like I took every black letter course I could find and worked pretty hard, despite going to that baseball game the first night. But to pay the outrageous tuition of $2,300 a year, I held down at one time or another in law school 4 jobs, not 4 at once, but 4 different jobs, sometimes 2 or 3 at a time. And so one of the jobs that I had that I found out very, very lucrative was that I got the franchise to run the Yale bookstore in the basement of the Yale Law Building. So one of the things that I did was there was a publisher who published basically, this wasn't the name of it, but they were basically cliff notes for law students. And so I would order those for various topics and sell them, and they were very popular. They were popular for the Yale law students who hadn't been to class and hadn't done their work, or who were out politicking or whatever. And these were basic cliff notes on basic things like, what is a tort? Or the fact that diversity jurisdiction has nothing to do with racial preferences, things like that. And I sold a lot of those and made a lot of money. And so that was one thing that was kind of descriptive of what Yale was like. Also, next door to my little store in the basement was an office that had been occupied at one point before I got to law school with one of the, shall I say, more revolutionary groups on campus, and it had caused a lot of turmoil among the faculty. And that group had taken a spray can of Dayglow paint. I hope everyone knows what Dayglow is, a psychedelic colored paint. And it scrawled on this door in the basement of the law school, "Home of the Dayglow Crazies." And that stayed there for the 3 years that I was there. How many law schools in the country other than Yale would have allowed that to stay there on the door? But that kind of reminded me. I mean, when I think of Yale Law School back then, I think, well, we could characteristically call it the home of the Dayglow Crazies. But the final little story is, so there were a lot of demonstrations in New Haven in the spring of 1970, and the campus was greatly disrupted, and we all lived in the law dorm back then. It was a great atmosphere because it was 24/7, running into your fellow law students and eating together and seeing each other in the library and whatever. It was a wonderful atmosphere in a fairly compact space. But anyway, in the middle of the night, the demonstrators broke into the International Law Library and set it afire there in the building. And so suddenly at 3 o'clock in the morning, people were banging on our door saying the building's on fire, clear out. So we all cleared out. The fire department came and quickly put out the fire. Fortunately, it was not that serious, but there was a lot of smoke. And so the law dean was summoned, and he called everybody together in the big lecture hall. And so we all went in listening, trying to what was going on, and he gave us reports of what he knew about what was going on. And then he said, and of course, the question is, what should we do about this? He says, somebody said we should go get a TRO, but frankly, I wouldn't know how. And that law dean, later, Bill Clinton appointed him as a federal district judge. So anyway, that tells you what it was like to be at the home of the Dayglow Crazies.
Let's go to a question. Gordon.
Well, I'm glad you mentioned the Hopwood case, Judge Smith. Today we get the oral argument recordings. We can see them on the website. But for some of the older ones and the historic cases, we can't just download the MP3. So I don't know if you have any sort of recollections of the argument or just kind of the case generally. And, I feel like if you ask your typical law professor, they're probably not going to give you the full story. They'll very quickly say Hopwood was just this decision, from the Fifth Circuit that they disagreed with. But just kind of, give an appreciation, I guess, for the people in the room, kind of what was that like and what were some of your reflections of the case?
Well, so what I remember the most is at the very end of the oral argument, the attorney for the state of Texas, who was from a major law firm, he was very, very fine, well-recognized attorney, in trying to defend the fact that Cheryl Hopwood had not been able to go to the University of Texas because of the affirmative action program that was being attacked. His final words were, and Your Honors, let's just remember that Ms. Hopwood could have gone to any of the other state law schools. To which I responded, sir, I called his name, but I won't now. It's a funny thing because that's exactly what the state of Texas told Herman Sweat back in the 1940s, that they would build a special law school for him because he was black and that he could go to that law school. And I said, that's exactly what you're telling us today, that Cheryl Hopwood is in the same situation as Herman Sweat and she can just go somewhere else to law school. You're asking me what I remember the most about the argument, and that's what I recall.
Yeah.
I enjoyed the reference to the 1960 World Series. I may like to plagiarize that sometime if I'm discussing the Electoral College. But I was reminded of the 1973 National League Championship Series, during which Justice Potter Stewart, received a note from his law clerk that said, VP Spiro Agnew just resigned, and oh, by the way, Mets 2, Reds 0, during oral arguments. I wondered if you had a favorite anecdote where your judicial duties cross paths with your passion for baseball.
Yeah, I guess I can't remember. I mean, I can recall lots of baseball games through the years, but I don't remember that it was particularly tied to my to my judicial career. Sometimes law clerks are tempted to write opinions with sports analogies, and I've done that a couple of times. But I think we've more used football than baseball. Yeah.
How unlike you. Couple other things I had. One, a really critical and fundamental question: how much mileage do you have on these cars, and how long have you owned them?
So my first Tahoe.
Did they go up Mount McKinley? Somebody told me something about that too.
My first Tahoe, I put 380,000 on it before it cratered. My current Tahoe, I only have about 230,000 on it. Our family, several years ago, many years ago, when we had younger children, and what we decided to do was drive in our own personal car to each of the 49 drivable states. And so we started doing, not all in one summer, of course, but we did it over a period of summers, and our last trip was a month-long trip, a round trip from Houston to Alaska. So we did go to all the 49 drivable states. We've done a lot of driving as a family.
Neat.
And by the way, tomorrow I got to drive from here to New Orleans
Right.
We
That's
have,
not, yeah,
we,
right.
we have in-bank court coming up. So.
Right. One other question I'm curious about is there've been this discussion of one well-known member of your court said, look, these courts that are not these schools that have people, they're teaching them it's okay to do everything under the sun, yell at judges, etc. I'm not going to hire clerks from there. And I know you'd had some questions about that, and I think there's certainly arguments made both ways. But I'm just curious if you have any thoughts on that.
Yeah, this is a matter on which reasonable minds can differ. I said that I thought that decision was. I think I used the word regrettable, and that's not the position that I've taken about boycotting students from particular law schools because of what the law schools are up to. My view is we hire the students, not the schools, and to say to a law student that he or she can't be considered for a clerkship with me because of a decision that young man or woman may have made to apply to law schools as a senior in college, and to say, too bad you may not have known it at the time, but by choosing law school X, that takes you off my list as a potential clerk. I think is not the best way to approach the problem. Again, good people have disagreed with that, and they've expressed a legitimate point of view that this is perhaps a way of bringing the law schools into line in terms of maintaining a better atmosphere for open debate at the law schools. But that's not my view. I accept applications from all of the law schools, and I look at the individual student rather than at the law school.
No, it's an interesting thing, but anyway, yeah, no, it's back to what we were discussing earlier. You can have disagreements with people, and and that's something which has frankly been a real problem. People don't try to really fully understand the views they most disagree with, and that's so valuable in understanding the person, not having the person seem hateful, but also you usually learn things yourself when you try to do that. It seems to me. So.
I think that's right, and people can reevaluate their positions. We never stop learning.
I wanted to do one other follow-up on Yale because I didn't realize there was a microphone over there. I'm sorry. Let me do that.
It's hard when you look into the light.
Well, it's also I was looking this way. I thought it was the only microphone.
So, Judge, of the dozens of other judges with whom you've served, who has made you laugh the hardest?
Who has made me laugh the hardest? Judge Jack Weiner is the best storyteller I think that there ever was, although Judge Hank Politz comes a close second. When they go to get into the Cajun jokes, some of which I couldn't even tell here.
There's ladies present.
They just had me rolling in the aisles. So.
Okay. Yeah, let me do one other Yale follow-up, although that was interesting. You mentioned some of the examples of some things that happened at Yale, but what was your sense of, I'll give you a hypothesis and see what your reaction to it is. My sense is that Yale, and probably many other schools, but Yale's the one we both know best, the students at the time, the left has become more radicalized since then, although there were plenty of radicals at the time, but supposedly students were hissed in class when they said anything conservative, at least at some stages in the law school. But on the other hand, I think the conservatives they're probably more conservatives than there were when you were there. Does that strike you as about right, or are you you have a very different perspective?
Yeah, I think that's right. And the way I describe Yale, and this is when I was there, Yale Law. This is a slight exaggeration, but not much, which is that the only two conservatives in the law school were me and John Bolton, a name that you may have heard fairly recently. It wasn't quite that bad, but almost. But there was not any kind of open hostility about people trying to confront others in the hallway or trying to shut things down or anything like that. And I think that sort of thing has increased over time. I mean, there was a lot of diversity of views at Yale, but it was more along the lines of shading on the left rather than on the right. But my recollection is that we all got along pretty well, and they all bought books from my bookstore. So I mean, I was not boycotted.
A version of Michael Jordan: Republicans buy sneakers too.
Yeah. But I think it's gotten apparently a lot worse. Yeah.
I think the last question I would ask is, over time, in terms of you've been a judge for a long time. Do you have any thoughts on either seniority, senior status questions, or more recently in terms of the courts, any kind of term limits for judges, which would, contrary to some crazy views, have to be done constitutionally if you did that. But anything in that area that you'd care to mention?
Well, number one, I obviously have a vested interest in saying there should be no term limits on judges. Lifetime tenure is a thing of great beauty and great wisdom for the founders to have instituted. I will say, of course, questions always arise about our career paths, those of us who've been on the bench a long time. And the question is, should we at some point take senior status? There aren't, I think the last count, there are only 5 of us who are active circuit judges appointed by Reagan. I believe that's right in the country. But in any event, so the question is, people sometimes say, they assume, oh, you already taken senior status. No, not quite. Well, what are your plans if someone is bold enough to ask? So I will say this, and you heard it here first, today. I have kind of made a decision about senior status, which is that I think I probably should take senior status toward the end of the second J.D. Vance administration.